Have you ever received a notice of invalid application? As an aspirant for Australian lifestyle and residency, you will want to do everything you can do to lodge a correct application and lodge it on time and in the location where you should be. Now in this video, I will give you some important information and tips on how to make a valid application to avoid situations where you unknowingly become unlawful and then lose the opportunity to lodge a suitable visa. Now this topic is the second of part 1 of the Australian visa and applications for Filipinos who want to migrate to Australia. Hi, my name is Teresa Cardona. I'm a lawyer and a registered migration agent from Auspac Visa, where we help Filipino professionals, partners, students, families, trainees, and our kababayans to migrate to Australia. If you are new here, please make sure that you click that subscribe button and hit the bell so you can be notified every time there's a new video from me. Okay, so let's start. Now, do you know that you can be unlawful when you lodge an invalid application? Now, even if you lodge the visa application on time, but if your application does not satisfy the validity requirements whilst your visa was expiring, you will be in the danger of getting unlawful. Now, usually, an invalid application is returned to you by the Department of Home Affairs a few days or weeks after visa lodgement, and by that time, your visa would have probably expired. It is normal for any visa holder to make a visa application at the end of the current visa. Now that is too risky because if your visa application is incorrectly done or invalid and your visa has expired, now you would then be effectively unlawful. Now, unfortunately, the notification of invalid applications does not come automatically. They are usually sent out after a week or two, which if you put your visa application at the end of your current visa would have been expired. And it will be too late for you to apply for a visa without successfully addressing other legal requirements. Now, making an invalid application may lose your chance of applying for the most appropriate visa. And you must know that the Department of Home Affairs only considers valid applications. Now, invalid applications cannot be considered and will be returned to you. Now, having said that, when your application is declared invalid by the department, it is invalid. It's not a refusal of the visa application, and therefore, there are no appeal rights in place. Now, the only course of action that you can take is to reapply if you still hold a valid visa, or if you no longer have a valid visa, you gotta have to make steps to regularize your status by making an application for a bridging visa or an appropriate visa that may allow a valid application despite being unlawful. Now, this can be very stressful and uncertain. So the best step really is to seek the help of registered migration agents or lawyers, and please do not attempt to do it yourself when your visa is about to expire. As I have said, a visa application must be a valid application to be considered for processing. If the application is a valid application, by law, it must be considered by the department, which means that consideration must be given to your visa application even if it's obvious that you will not meet the criteria specified in the type of visa that you are applying for. Now, the processing of the application will continue until it's either withdrawn, refused, or granted. Now, in the same way, if the visa application is invalid, it would not matter anymore how complete and thorough it is. It will still be returned and will not be processed by the Department of Home Affairs. Now, an invalid visa application seldom happens nowadays due to use of electronic lodgement via IMI account. Now, in most situations, IMI account prompts the applicant if there is an error or something wrong in the application. Now, if you receive an error notification, then that means that you must be doing something wrong or are putting information that is not consistent with the department records. Now, when technical errors happen, it is hard to properly identify the issues. Now, to avoid or to solve issues like this, it is best to contact your reputable registered migration agent in the beginning to know exactly what you will be dealing with. As I've said, it is best to give the visa application to the professional rather than doing it yourself. Because, immigration law is a complex area of law. Expertise and experience of reputable registered migration agents or lawyers will make it a breeze for you to obtain your visa. Now, going back to valid visa application. Now, you would ask, what is then a valid visa application? Now, for an application to be considered as a valid application by the Department of Home Affairs, it must be done using one, the correct form, either on paper or electronic format. Two, you have to have paid the correct fee. Now, the visa application charges are published in the immigration website. There are also some specified situations in which the visa application charge is waived and certain visas are free. Now, third is you must be in the correct location. And then fourth, you have provided information such as residential address, including all the details that are in your passport. Fifth is that you are not legally barred from making an application. And then six is that your visa allows you to make further application while in Australia. Now, some visas have specific validity requirements that are unique to a subclass or substream within the visa subclass. Now, for example, when the visa you are applying for requires sponsorship and nomination, you will not be able to proceed without those things, and your visa application will not proceed. Now again, if you're not sure and to avoid the stress and mistake that cannot easily be undone, you have to see registered migration agents or lawyers because they have access to the applicable laws and would know the legislative basis why and how visas must be made. Now, in regards to the location of the applicant, now the law will generally specify whether the applicant needs to be in or outside of Australia at the time of application and where the application must be made. Now, in some situations, applicants can be permitted by the regulations to apply for a waiver. However, the waiver must be applied for before a visa application can validly be made. Now again, this may seem very simple, but this is the cause of the many mistakes with the visa application. If you are unsure, seek the help of RMAs and lawyers. Now, the question is there a bridging visa after visa application? Now, a valid application for a substantive visa normally obtains a bridging visa. Now, the type of visa you are applying for and your circumstances when you applied for a visa will determine what bridging visa you would get. Now, for example, bridging visa A for you to stay in Australia while waiting for the outcome of the substantive visa that you have applied. Now, there are different types of bridging visas, which we will not discuss here because it's complex and long. I will leave that to another video in the future. Now, the common question is, can a person validly apply for a substantive visa if he or she has been refused or canceled the visa? Now, the short answer is no, except for some limited type of visas. Now, the intending visa applicants who are in Australia can only validly apply for the following visa: partner visa, protection visa, medical treatment visa, territorial asylum visa, border visa, special category visa, bridging visa A, B, C, D, E, F, and R, resolution of status visa, child visa, retirement visa, and investor retirement visa. Now, if you were refused or have been canceled the visa, you will no longer eligible to apply for any substantive visa except for those visas that I mentioned. Now, this is so in order to prevent any person without substantive visa or with canceled visa to make a repeat application while in Australia. And also to make sure that anyone refused or had a visa canceled won't argue that they either did not make or understand the nature of the refused application or reason out that Section 48 bar does not apply because they left Australia following the visa refusal or cancellation. Alright, so what are my tips? Now, tip number 1 is apply for a substantive visa on time. Avoid delays or procrastination. 2, always make sure that you have all the correct information and supporting documents handy. And 3, acknowledge that your ability to do and handle a complex case like this may be inadequate and the likelihood of making a mistake is very high. Now, 4th, always seek an experienced and reputable migration agents and lawyers to help you with your visa application. Now, okay, so that's all for today. Now, in this video, you have learned what a valid visa application is, the dangers of making an invalid application, and what to do when your visa is invalid. Now, I have given you some tips on how to make a valid visa application. And watch out for the next video as we discuss the visa conditions, including the no further stay visa and how to apply for a waiver. That's all. So see you next time. Bye!